John, let me pick up a little bit from what Craig said regarding Eric Holder. He's there, as they put it, on his own, not at the request of the president specifically. But you've got 40 FBI special agents and other Justice Department officials fanning out across Ferguson, gathering information here. There's an article out that discusses from the McClatchy Washington Bureau. They discuss some of the options that await the Justice Department. In it, of course, they say the most emphatic outcome, a potential federal civil rights prosecution of the police officer who shot Brown, may be the least probable because of the standards of proof required. I know that you've been heavily involved in civil rights cases. And what is your take on that being the least probable, according to some analysts?
Well, the reason why is a specific intent crime that you have to specifically intend to commit that crime. Although I will say that that crime has been prosecuted before. We certainly had it in the Rodney King case. It requires that you did what you intended to do. And so that can be done. But I think what the Fed government is looking at is not only are they looking at the federal criminal civil rights aspect, but they're also looking at the federal civil rights act, which is a different cause of action. And they're also looking at whether or not there's a long-standing pattern and practice of discriminatory conduct. That's something else that the feds could look at. But on balance, what he wants to do right now is to make sure all the evidence that's available is gathered, so that if there's any witnesses there, any corroboration for any of the witnesses, the pathology reports where they're doing an independent one, any of the ballistic testimony that's out there that shows where the bullets were fired. You want to determine the distance that the kid was away from the officer when he was shot, and what happened at that car, because that's critical. So at the end of the day, not only the feds, the Justice Department, they have to evaluate all of this to determine what type of crime, if any, has been committed. And so what he wants to do is get this evidence now while it is fresh. I must say the District Attorney's Office should be doing the same thing.
Yeah, and let's take it back to the District Attorney's Office and the state level here. You have this grand jury convening. Missouri Governor Jay Nixon yesterday said he would not seek the removal of the St. Louis County prosecutor Bob McCullough involved in this case. The state's attorney general says the governor does not have the ability to replace McCullough. Only a judge can appoint a special prosecutor. Many questions surrounding this decision. Nevertheless, this grand jury will move forward here, but this will not happen. The results of it anyway won't happen overnight, correct?
Yeah, grand juries take a little bit of time because all of the evidence has to be gathered, and they don't meet every day. I mean, they may meet once a week, and that, it's not uncommon for a grand jury to take over a month or two to gather all the evidence. Sometimes it can be even longer than that. In this particular case, they have a couple of areas that they have to be focused on. One, they have to focus on what happened at that car, and do they get a statement from the defendant, the police officer at that point in time? Do they have to look at other witnesses? Then they have to look at the physical evidence. It's very important to know where the ballistic evidence is. That is where the gunshot shells are, and to try to find out what the distance was where the young man was from the police officer, because at the end of the day, you got to be able to evaluate how those bullets went into his body and what position he was in. If you can do that, that goes back to the pathology. So there's a lot that has to be done here, but it can be done. It doesn't have to take years to do. I think in many ways it's not that complicated to determine whether or not a crime has been committed here. What I would be concerned about here, as having done these kind of cases, is whether the prosecutor in this particular area has the experience to prosecute a police officer, because they're not accustomed to doing that. They may be wonderful lawyers in prosecuting ordinary criminal cases, but it's a different dynamic when you're prosecuting a police officer in the very community in which
Why is it a different dynamic when the law doesn't change? The law doesn't change from neighborhood to neighborhood. If you're prosecuting a young black man versus a young white man, the law should be the law.
The law is the law, but the question is, how do people interpret it? People honestly, they give police officers the more benefit of the doubt, particularly if it happens while they're on duty. And a prosecutor is not accustomed to prosecuting police officers. The jury selection process is totally different. The officers themselves are not as cooperative with the district attorney's office as they normally are when they're prosecuting a young black man. And so you're different with a different dynamic. You need someone who has experience doing that. And no matter, even though these are good good, maybe very able prosecutors. I bet they've never really prosecuted a police officer in the very community in which this case has taken place. We've seen that in other cases I've been involved in. We saw that in Rodney King. We saw that in the Oscar Grant case. We see that often. So,
and this DA's background and his connections to police officers and his family, as well as a history regarding cases with police, has also been brought into question, to your point. But I have to just quickly ask you about the officer himself. Officer Wilson has been given the option to testify before that grand jury. What is your thought there?
Well, that's a Fifth Amendment question. If you're the target of the grand jury, you are not required to testify. The defense lawyer who represents him has to make a decision as to whether he thinks his statement, that his client can make a good enough statement to persuade the grand jury that what he did was justifiable. But if he cannot do that, then he should not testify, because we're talking about levels of homicide here. You're talking about a first degree, second degree, manslaughters, and if he wants to talk his way out of this, he may be trying to talk his way into an acquittal, or he may be trying to talk his way into a lesser charge such as manslaughter, because you do have elements of all of those there. That's not a smart move necessarily to put him on. It's a gamble. It may not be as much of a gamble in a district where police get the benefit of the doubt, but it is one that the defense lawyer has to make a hard decision about, because normally the defendant, who is the target of the grand jury, does not testify at the grand jury.
John Burris, thank you very much for your time. I greatly appreciate it.